we've been tracking the rollout of the COVID-19 vaccine to first responders. We've seen many a photo and video of doctors and nurses and other healthcare workers getting the vaccine. We've talked about the elderly receiving it next in nursing home facilities all across Texas and across the country. Quentin Brogdon is a Dallas attorney, and he's been attached to the COVID-19 pandemic in a number of ways as it relates to the law. And we're talking to him this morning about what the legal fallout could be, or what the legal guidance is on getting the vaccine in the workplace. Quentin, thank you for joining us.
Good morning. Thanks for having me on.
You bet. Let me ask you, can an employer make it a condition of your employment that you get the vaccine?
Probably employers can now do that. Under the federal and state regulations, employers have a duty to provide safe workplaces for their employees, and that includes keeping them safe from COVID, particularly if those employees work in high-risk environments, hospitals, nursing homes. Employers can and probably should require their employees to be vaccinated. It gets a little trickier if you're in a white-collar job, not necessarily exposed to the public, but even in those circumstances, based on some federal guidance from the EEOC, the Equal Employment Opportunity Commission, within the past week, employers can require those employees to be vaccinated.
What about, particularly among those who have religious beliefs, that they can make a case based on those religious beliefs that they shouldn't get the vaccine or can't get the vaccine, both religious and medical reasons? I understand there are carve-outs for that, but how much of a gray area is that? Can an employer hold you to account to prove the medical condition or prove the religious belief, and how do you do that?
Well, the EEOC clarified, and it already was the law, that if you're requiring an employee to do something such as get a vaccination, you need to accommodate sincerely held religious beliefs under a law called Title VII, a federal law, and also disabilities under the Americans with Disabilities Act. That could be an immune disorder where you're more susceptible to adverse reactions to the vaccine. So employers in those circumstances need to make reasonable accommodations, and that might involve letting an employee work from home, for example. And economic hardship in and of itself on the employer is not going to be a basis to absolve the employer of having to make reasonable accommodations.
I'm curious to know if you are anticipating some legal fallout from this, that you will get a phone call from an employee who says, I was let go because I wouldn't get the vaccine, or conversely from an employer who says, I've got an employee suing me because I made them take the vaccine.
My advice to employers first is, whenever possible, make this voluntary. Try to incentivize your employees to get the vaccine. If you're going to make it mandatory, do not administer the vaccine yourself, because you can run afoul of some federal regulations and laws if you do that. Have it done, have the employee go do it by their physician or at a pharmacy, something such as that. And don't administer the pre-screening questions yourself. If you're an employee and you have legitimate concerns, sincerely held religious beliefs or otherwise, it is good to raise those with your employer on a timely basis and try to work together and see if there's an accommodation that can be arrived at. Perhaps working from home, for example, if that can be done in your job. It's always better in these circumstances to try to do things by agreement. Anybody can file a lawsuit. Part of my job all day, every day, some of your listeners will be surprised to hear, is telling more than 9 out of 10 people who approach me about possible legal cases is, I'm sorry, I just can't help you on this. You don't have a valid legal claim, in my opinion.
Yeah, for every case we hear about, there were so many others that just simply didn't have any legal standing. Before we let you go, I want to ask you about Maurice Dotson's family. I know you represented them after Maurice's death back in April of COVID-19. He worked as a nurse's aide at West Oaks Nursing and Rehabilitation Center in Austin. The family had alleged that the nursing home simply waited too long to provide PPE. Do you think we have learned from this pandemic, not just from your cases or by legal action that was taken, but in general, have we learned how to better take care of our frontline workers should we be hit, God forbid, with another pandemic?
We ask our frontline workers at great risk to themselves and to their families to take care of our loved ones. Many of us have loved ones who are in nursing homes, assisted living centers, and we need to make sure that they're taken care of. And when they're not taken care of, we need to hold those facilities accountable. The idea that this pandemic is completely unforeseen and something that just came out of the blue is just not true. We've known about respiratory diseases wreaking havoc in nursing homes and assisted living homes and centers for a very long time. So the standard hasn't changed. It's just this pandemic has swamped some of those low-sitting boats in the water, and they need to be held accountable. The answer is not immunity for those facilities. The answer is to let a judge and a jury weigh in on their accountability.
Yeah, point well made there. Thank you very much. Appreciate it, Quentin. Quentin Brogdon, a Dallas attorney, speaking to the legal issues you may face in the workplace. And if you have a legal question or a possible case, you can reach out to Quentin. There is his information on your screen.